Dorothy, the registration list has been sent to you.
Okay, great. Okay. I just want to write down the title of this. I think I have. All I have to do. Pardon me?
Go ahead.
Okay, so it's just, all I have to do is mention OVW, part 2 of this training that you will be co-hosting with us.
Right, and you know, your agency name, and that's it.
Yeah. Yep. Okay. I just want to write down the title of the training.
Hi, everyone. Welcome. If you can mute yourself as you come in, or say hello and mute yourself.
Okay.
And as we gather up, if you want to go ahead and put on the chat what agency you're with and where you're from or where you're watching us from today. And go ahead, Leslie, we're ready to start. We're going to let Dorothy start us off.
Okay. Hi, this is Dorothy Strassman from Opportunities for Otsego, the Violence Intervention Program, and I'd like to thank you for joining us. We're now going to hear a webinar entitled Legal Rights of Immigrant Survivors, Immigration Relief, Public Benefits, and Protection Orders. It's part 2 of an Office on Violence Against Women sponsored grant. And we are going to be co-sponsoring this with the National Immigrant Women's Advocacy Project from the Washington College of Law. And if you were able to participate in the first part of the training, you'll realize how incredibly informative it's been. So I will turn it over.
Welcome, everyone. My name is Leslie Orloff, and I direct the National Immigrant Women's Advocacy Project at American University Washington College of Law. I'm glad you've all joined us here today. I want to encourage you as we go forward to ask questions in the chat as we move forward. And so I'm a family lawyer and have been involved in working on the Immigration Prohibitions of Violence Against Women Act. And we're going to be talking about that and public benefits access a lot today. So I welcome you here and look forward to doing the training for you.
Hi, good morning, everyone. If you can mute yourself if you're not on. We do want to hear from you, and we have opportunities to be interactive, and we have a section of questions. My name is Rocio Molina. I'm the Deputy Director here at NUAP, and I work with Leslie. My expertise is in immigration law, and we provide technical assistance, which means resources and information to everyone around the country. Anything to do with immigrant victims, family law, immigration law, public benefits, safety planning. And so that's a little bit about us. Can you guys raise your hand as to who joined us in part 1, where we covered a lot about the U visas, our crime fighting tool, and we had Detective Sonnenberg and Detective Frechette joined us for that webinar. So I see some of you guys were able to join us, and I'm glad, and we hope we're able to pick up on what we learned that on part 1 with today.
Wonderful. And I believe that the recording for part 1 will be available together with the recording for today. So if you're joining us today for the first time, we will be giving you some background, and you don't have to worry about that in terms of you can watch these two pieces in any order, and we'll be sending you a link following the webinar that has access to the materials and to both of the video recordings. So our learning objectives for today is by the end of this webinar, you will be able to understand how filing for immigration relief enhances access to public benefits and the safety net services for immigrant survivors. We're going to help you quickly identify which immigrant victims and their children could qualify for which types of publicly funded benefits and services in New York. And I love doing this in New York as opposed to some of the other places we go, because New York has many, many, many more public benefits and services access. It's one of the better states. No state is perfect. There's always some state where another part is better, but there are a lot of states that don't offer much more, or some who offer less than the federal minimum. And New York is definitely not one of those. So it also keeps my brain functioning because I have to figure it all out for each state. And I'm going to try to make that simple for you. And then finally, so we're really going to be focusing on immigration relief as it relates to public benefits. And then we're going to be talking as the third chunk about Vawa Confidentiality, which are the protections from removal available for immigrant survivors. Right, so that is like our project for today. And the title was actually wrong. We're not going to be discussing protection orders in great detail today. If you have questions about those or any other issues, please put them in the chat and we will continue as we go forward. Next slide, please.
So let's see who's all with us. If you can go ahead and type it up in the chat. What's your role in your organization and what best describes you? So A, if you're a victim advocate or coalition staff. B, if you're an attorney. C would be prosecutors, law enforcement, or victim witness that work within those agencies. And then E, others. Okay, so we have a great number of victim advocates. We have some attorneys, some accredited reps or other legal, paralegal support staff. And so a good mix. I want to let you know we did provide a lot of slides here, and that's mainly so that you can quickly and easily turn to here as a resource. We want this material to be something that you can easily pull up and refresh your memory if you need something. Here to support you afterwards.
And if everybody could please silence themselves, that would be great. So what we're going to do is we're going to start from the last training. We did a little bit on demographics. I'm going to just give an update because I updated the slides since then. So next slide, please.
Sorry, Corey, I'm trying to find the link now.
Where do you, what are the top 5, if you type in the chat, languages other than English that you believe are the ones spoken in New York?
And so go ahead and put that in the chat. Arabic,
Bengali, Mandarin, Chinese, Burmese, Urdu.
Okay.
You guys are good.
Send it to
Spanish, Russian, Italian, absolutely, Haitian Creole, French. Okay, so Rocio, maybe 3 slides forward, please. So we have a slide here that talks about the demographics, but when we look at languages spoken, you did a very good job. Got most of them. Portuguese, somebody just put Portuguese. It would be the one right under Hebrew at the bottom. I put them in order of the biggest to the smallest numbers. But Spanish, Chinese, Russian, Yiddish, and Haitian are the first 5, followed closely by Bengali, other Indo-European, and Italian. You have more Italian speakers at home than you do Arabic speakers at home, for example. But you also have a lot of other languages, very diverse in terms of languages spoken at home. And what's interesting is, next slide, please. Yes, so what's very interesting about you have a very high percentage compared to other states, actually, of non-citizens who are limited English proficient, with 56, almost 57% in the state. But it's very interesting because where language acts, the percentage of language access proficiency varies dramatically by country of origin or language spoken. And we only listed the ones where there were at least more than 32,000 people in the state who spoke this language, who were limited English proficient in this language. So the top 5 in terms of limited English proficiency are Chinese, Russian, Korean, Bengali, and Spanish, followed closely. Spanish and Yiddish are tied for 42%. So you have, again, great diversity in who is LEP in New York, but not the same as the languages spoken at home. Next slide, please.
Okay. Thanks for that information, Leslie. And I think that the demographics are available on our website. And, you know, years from now, when you want to get an update, go ahead and check us out. That's really important to know who's coming to your agency, what survivors you're seeing, and maybe who you're not seeing. Maybe there's some languages and populations that are large in your state, but you're not seeing them in your organization. And that can be a note on how figuring out what is going on there. Next, we're going to go into immigration options. And the reason why we're going to go into talking about the different options for immigrant survivors is because it's dependent, it determines what public benefit somebody is eligible for. And so there's going to be some details here where you can reference back, but one of the first steps that we want to accomplish here is to help you identify and help you screen for which immigrant survivors might be eligible for which remedy. So starting with the purpose of the protections, Leslie was part of the writing of the Violence Against Women Act, Immigration Protections for Immigrants. And if you can tell us a little bit about what Congress intended when they created these, Leslie.
Sure. So when Congress enacted all of the immigration protections, starting actually in 1990 with the Battered Spouse Waiver, but the Violence Against Women Act, U visas, T visas, special immigrant juvenile status. When you look at all of them, it was to help victims of abuse and crime victimization occurring mostly in the United States, although in the context of SIJS, special immigrant juvenile status could happen abroad. There are also some VAWA cases where that might be possible. But basically victims of crime victimization and abuse in this country, in order to increase protections for victims, but also hold offenders accountable and allow survivors, remove the barriers and the power and control over immigration status barriers that preclude or inhibit the ability of victims to come forward and report abuse to your agencies, to police, to prosecutors, to seek help from the courts. And so it was, and the Congress understood that by enhancing victim safety and offender accountability, that is how we keep our communities safer from the kinds of recidivist crimes that and abuse that that VAWA protects against.
And so a survivor that applies for any of these benefits, they get protection from deportation. They will get protections under Vawa Confidentiality. And as Leslie said, that's what protects, of course, the confidentiality of the cases and how perpetrators can interfere with it. But also as a way, it offers great protections for survivors. Survivors can also include family members in their application, so their children and spouses in some cases. It will give them access to legal immigration status, and if they want to remain in the U.S., then they can apply for residency and later U.S. citizenship. And it allows for financial independence from the perpetrator, so they're able to get work authorization. With that, they can get federal recognized ID, social security number, and then they're able to get access to some public benefits. Here's a demographic, and we have it shared in your materials, but this is a great tool to have printed up there or share with others. It clicks on, it's a shield, right? Because it's protections, and it talks about the protections that we're going to talk about today, which is the VAWA self-petition. You can click on it. It has links to USCIS's forms. It tells you what the eligibility criteria is and what the survivor gets and the timing. The U visa, that's for crime victims. Continued presence is for those that are cooperating with prosecutors or law enforcement. Special immigrant juvenile status, SIJS for juveniles, asylum, and T visa for trafficking victims. This next list shows you the types of crimes or behaviors that if an immigrant is a victim of these, it includes the U visa qualifying crimes. So crimes that we see that people are the most vulnerable are often targeted. And it includes, domestic violence, which includes battery, extreme cruelty, child abuse, then the U visa crimes, and then also the crimes that someone that would be eligible for SIJS, which is parent perpetrated child abuse, neglect, or abandonment. Also, attempt, conspiracy, solicitation of any of these activities may make an immigrant victim eligible for relief. The first of these is the VAWA self-petition requirement. The way I screen to determine if an immigrant is eligible for this is first I look to see who the perpetrator of the abuse is. You want to identify if they're a US citizen or lawful permanent resident. So there has to be that relationship. And that could be either from a spouse, a parent, or a step parent. And so, in some cases, it could be an adult son or daughter. That person had to be subjected to battery or extreme cruelty. So we don't necessarily have to have here police reports or physical violence. There could be many behaviors that can constitute extreme cruelty. The survivor had to have resided with the perpetrator at one point and not a set amount of time is required. That person has to be of good moral character. If the relationship is based on a spouse, then the marriage must have been entered in good faith. There's relief for those that are facing deportation or removal, very similar to this, and it's called cancellation of removal. It's same requirements, but this is for someone that is already before an immigration judge. And then in some cases, a spouse starts the immigration process for the other, but either due to abuse or for other reasons, for safety, they're no longer together. And then there's the battered spouse waiver. We're going to have a webinar this fall on battered spouse waiver. So with this registration, we can send you information on that and you can learn more about that. One of the questions is, how is good moral character assessed? And they look back at the survivor's 5-year history. And basically, we're looking to see somebody that doesn't have any criminal background or limited criminal background. And so they look into that. A victim can be here undocumented if they're applying for a VAWA self-petition.
Right, and they're not, the other thing about that is that they're not looking at undocumented status as anything criminal. That's not the issue. And there are special waivers. So let's say the victim has a criminal conviction, but she stole $15 of baby food fleeing in the snow in northern New York in the middle of the night from her abuser, and she stole it from a 7-Eleven, $15 worth of it. And if you can show a connection between the abuse and the crime victimization, those things can be waived. There are special waivers for victims. So it's one of those things that as good advocates or attorneys, you want to find out from your clients as soon as possible if they have criminal histories, and to not be worried or afraid about that. It's something that can be waived, but you have to identify it, and you don't want to file a case before it's been identified so that the victim can request various waivers. And a lot of these programs have different kinds of waivers, and that's just one example.
Yeah. And so if you have questions about good moral character, reach out. I would never want to tell somebody they weren't eligible without getting a second or third opinion. The other form of relief, well, actually, I wanted to tell you a little more about extreme cruelty, because the next form of relief, the U visa, requires being helpful to law enforcement or prosecution or with a judge. But for the VAWA self-petition, I told you the abuse is either battery or extreme cruelty. And here are some examples of what constitutes extreme cruelty when USCIS is reviewing those. And so that includes emotional abuse, economic abuse, sexual abuse, coercion, threats of deportation, immigration-related abuse, so taking of documents or saying they're going to report them to USCIS, intimidation, isolation, degradation, or possessiveness or harming of pets. And this isn't an all-exclusive list. This is just some examples. But this is just to give you an idea. Sometimes you see one of these and sometimes they look at the whole circumstance and you can see these. And one of the ways that I identify this with survivors is using the immigrant power and control wheel. And I'll share that with you later down in the presentation. The other form of immigration relief is the U visa, and this is for crime victims. And so here, the immigrant victim has to be a victim of those qualifying criminal activities, the ones I shared with you in the first slide. Largely, we see a lot of domestic violence or sexual assault, stalking in our work. And so one of those qualifying criminal activities, the person has to have been or likely to be or will be helpful in the detection, investigation, prosecution, conviction, or sentencing. The person had to have suffered physical or mental abuse as a result of being a victim of that crime. They had to have possessed information about the crime, and the crime had to have occurred in the US or violated US law. Every person that applies for the U visa needs to have a U visa certification. And that is a document on an immigration form, but it is assigned by either law enforcement, prosecution, judges, or a range of other officials that have investigatory authority. So CPS, Adult Protective Services, and they certify that the person was in fact a victim and that they were helpful. And so it's very important to have good relationships with your partners in order to be able to support an immigrant victim, crime victim applying for the U visa. The timeline for the U visa is about 6 years, sometimes a little more. That's a timeline to work authorization and waitlist approval. But this summer, there's been some changes and that will allow for applying for having a bona fide determination early in the case. And we're very hopeful to start to see a lot of immigrant survivors that are crime victims being able to get that work authorization early, which we know is crucial to safety and self-sufficiency. Here's the T visa. The T visa is for victims of a severe form of human trafficking. It could be in the sex context or labor trafficking. If it involves a victim under 18, victims under 18 don't have to show fraud, or coercion under sex trafficking. The victim has to be physical present in the United States on account of trafficking. They have to comply with reasonable requests for helpfulness in the investigation or prosecution, similar to U visa. There's exception for victims under 18 or for victims that have physical or psychological trauma that impedes them from being helpful with the cooperation. And they must show that removal from the US would create hardship. Here, work authorization and approval is much shorter than the U visa, and they also have a larger access and wider range of public benefits as they have access. So earlier when I showed you the list of crimes, human trafficking is covered by both the U visa and the T visa. But if somebody is eligible for the T visa, you want to go ahead and apply for that. A little here about special immigrant juvenile status. This is for immigration relief for unmarried children. And the age of they consider what the age of the majority and under state law. It's for victims of abuse, abandonment, or neglect, or dependency by at least one parent. So it's not necessarily that they are completely abandoned by both parents. It's just that one parent had to have been the either perpetrator of abuse or abandoned or neglected the child. Each person that applies for special immigrant juvenile status needs a state court finding, and where the judge makes those determination, shows that they have jurisdiction over the care and custody and dependency of the child. The timeline for the special immigrant juvenile status is again much shorter than U visa, and it offers more protections. And so for those children of maybe VAWA self-petitioners or U visa, they might also be eligible for special immigrant juvenile status. And we want them to apply for this remedy because it'll give them access again to public benefits and to relief much sooner if they were waiting in line for the U visa. So as I mentioned earlier, all these forms of immigration relief have some benefits for the children or family members. The VAWA self-petitioner can apply for their children. They can, a parent, you could be, if your child is abused, you can apply as the parent of an abused child. You can include all children under 21, and you could also include the parent. For U visa and T visa, they can include children under 21, the spouse, children, parents, and unmarried siblings under 18. And then for special immigrant juvenile status, it's just for that child, and they will not be able to include any other family members. So let's look at what this looks like. This is something, something similar that we get called on with our TA. I'll let you take the lead on this one, Leslie.
Okay. I've been putting things in the chat that are answering questions and sending you links to materials. Rocio and I will trade off on that as one of us talks, the other will type. Anyway, so this scenario is so that you can see essentially how easy it is to identify who might qualify for what on the fact patterns that you guys are regularly looking at. So I'm going to read you this fact pattern, and then we're going to give you some multiple choice questions. So Clara met Eduardo, a lawful permanent resident, when he came back to his hometown to visit his family in El Salvador. Eduardo started dating Clara, who was raising her 9-year-old son, Miguel. After Clara became pregnant and gave birth to a baby girl, Lupe, Eduardo decided to bring Clara, Miguel, and Lupe to the US to live with him. When they arrived in the US, Eduardo took Clara, Miguel, and Lupe's passports and became physically and sexually abusive of Clara and abusive of Miguel, who tried to protect his mother from Eduardo's abuse. Eduardo also physically beat Lupe when she misbehaved. Within a year following their arrival in the US, Eduardo forced both Clara and Miguel to work for his family's business and never paid them for their labor. One night when Miguel was 13 and Lupe was 5, Eduardo's rage led to severe beatings with a belt of Miguel and Lupe. When Clara intervened to protect the children, Eduardo strangled her until she passed out. The neighbors called the police for help. Clara talked to the police when they arrived. The police arrested Eduardo for attempted murder and child abuse and took Clara to the hospital and placed the children in the care of the state. So the first question that we're going to ask you is, what forms of immigration relief would Clara qualify for? Based on what Rocio told you in the slides, you don't need to go back. It's fine. What would she qualify for? So it's U visa, VAWA self-petition as a parent of Lupe, T visa, and all of the above. And I'm seeing a lot of Ds, I'm seeing a lot of alls, I'm seeing some Bs. Still coming in. And Rocio, what's the answer?
All of the above.
And can you walk us through why?
Okay, so as I'm screening for the VAWA self-petition, I'm going to look to see what status the abuser has. And so here, I'm going to look to see Eduardo, and I see that he's a lawful permanent resident. So that's my first clue to look at that. But next, I'm going to make sure that they were married, legally married, because that's one of the requirements. So
they are not.
And they are not married. So she's not eligible for VAWA self-petition.
As the victim herself. However, what you also have is Lupe is the daughter of a lawful permanent resident. And so Lupe could file a self-petition because she's an abused child of a lawful permanent resident and include her mother, but not her brother, in her application. So Clara is eligible as the mother of Lupe.
And not her brother, because her brother is a US citizen, right?
No, not her brother, because there's no marriage. And her brother is a stepbrother. So if there were a marriage, Miguel could self-petition, but there's no marriage. We're giving the next answer. Let's go forward a second. Oh, and then Clara is eligible for a U visa. Can I just see the questions we answered, not the scenario?
Yes.
Thank you. She's eligible for a U visa because of the abuse, and she's eligible for a T visa because she was forced to work by her boyfriend for his family, and never paid for her labor. And T visa can be very important because even in New York, there are times when if Clara goes for a T visa, she will get public benefits that she wouldn't get as a U visa or a VAWA self-petitioning applicant. Next slide, please. So we're going to do a similar thing for the kids. And I kind of gave it away, but what does Miguel qualify for? Of these, there are 2 of these, I think so, yes, that Miguel qualifies. Which 2?
I'm going to go back to it, okay? So we're going to go back to Miguel.
They need to see the options though before you go back, Rocio. The options are more important than the story at this point. So is he eligible for a VAWA self-petition, a U visa, a T visa, or SIJS? So I think some people are saying C and D, some people are saying D, some people are saying B. Okay. Okay, so I'm going to walk you through actually, okay. I'm going to walk you through this. So, and I don't need to go back to the story. So the self-petition, the answer is he's eligible for a U visa and a T visa. He is not eligible for a VAWA self-petition or SIJS. And the reason is there's no marriage. So if Clara had married Eduardo and Eduardo was Miguel's stepfather, then he'd be eligible for all 4 of these. But because there's no marriage, he's only eligible for the U visa and the T visa. That's how it works. Because the marriage is needed, the step-parent, stepfather, stepchild relationship, which, by the way, for VAWA self-petitions, brand new law, the case out of the 5th Circuit, divorce between, let's say Clara and Miguel were married and got a divorce, the divorce no longer cuts off Miguel as a stepchild. Once a stepchild relationship is formed through marriage, it doesn't end by divorce for VAWA self-petitioning purposes. So that's how this works. So you can see Miguel has lots of either 2 or 4 options. Let's go to Lupe. And so the question is, what forms of immigration so here I'm asking you a different question. And that is, what form of immigration relief would Lupe not qualify for? Okay. So we're seeing SIJS, C, T.
Lupe is the baby girl for those of us.
Is the baby girl.
Mhm.
Okay. Give me a few more seconds. Okay. So we're
A
seeing
lot of TV says here.
Yeah, we're seeing a lot of T visas. That's correct. She's not eligible for the T visa because she didn't do the traffic. She wasn't trafficked. There's no labor traffic. Now, if Clara files or Miguel files for a T visa, because Clara could be included in Lupe's T visa as a child or Miguel's T visa as a sister because of her age. But Lupe can self-petition without regard to the marriage because her father is a lawful permanent resident. He's the perpetrator. She's eligible for SIJS because her father is the abuser without regard to his status. And she's eligible for U visa because she's abused because of the child abuse. That's kind of how it works. And child abuse on the U visa list falls within domestic violence in all states, well, most states, except for like 2, and New York isn't one of them. So your domestic violence, state domestic violence definition includes child abuse victims. Okay, next slide, please. So what does this mean? Because we're talking about immigration relief today to understand its impact on benefits. So what this means is that, so let's just take a look at big benefits. TANF, which is, economic relief, food stamps, housing, and education. So if Clara and Miguel pursue T visas, then the T visa, or if Lupe files a self-petition as the mother, or actually if other way around, if Lupe self-petition and includes her mother and her brother, your mother in her application, they could qualify for TANF in New York. So T visa is national. TANF is a New York benefit that's available. If Miguel goes or Lupe go the SIJS route, they don't qualify for TANF in New York until 5 years after lawful permanent residency, which can be as long as 8 years. And they won't qualify until in New York and for TANF until their lawful permanent residence. Under the U visa, that could be 26 years. Could get shortened a little bit, but not by much. Food stamps, under the T visa, Clara and the children, if Clara files a T visa includes her children, they're all eligible. Child VAWA self-petitioners are eligible within 3 months. So if Lupe files a self-petition, she can get food stamps in 3 months. If she files for SIJ, it's a little bit slower access to food stamps. Clara would have to wait. If she files, she can't self-petition because she's not married, but if she could self-petition, if there was a marriage, it would be a 5-year wait and a 26-year wait for a U visa. In terms of access to public housing, let's say they're living in a public housing unit in New York with Miguel, as VAWA self-petitioners. So if Lupe files a VAWA self-petition that includes her mother, and let's say Miguel files for a T visa, everybody's eligible for public housing with no proration. If they go the SIJ route, they have to wait, or U visa route, they have to wait till lawful permanent residency. FAFSA, T visas, immediately eligible. VAWA self-petitions have to wait basically only 3 months after filing. SIJS and U visas, it's lawful permanent residency, and it's those same 1 year to 21-year wait period. So that's how choosing the immigration relief, understanding the benefits implications are really important. And that's what we'll be talking about today. Okay.
Yeah, thanks for breaking that down, Leslie. And, we're here to support you, but we just wanted to show you the impact as to which remedy that you choose, how it can impact the wait for the relief.
And just so you don't get overwhelmed, because Rocio's reminding me when we say this, is we have some really good tools that we'll be showing you later, like a map where you can click on it. And anybody who's sitting before you, you can click on the map and see what they're eligible or potentially eligible for in New York based on which program, which federal or state benefits program you're looking at. We're going to get to that later in the webinar. Back to you, Rocio.
And then one of the questions is, if there were no children, would she be able to access public benefits with prima facie?
Right. So what happens is there's two things. A prima facie determination is so let's assume Clara is married to Eduardo and she's VAWA self-petitioning, then she would get a prima facie. When she got her prima facie, she would be immediately eligible for some public benefits. Biggest examples are housing and education. But TANF, actually in New York, it would be housing, education, and TANF. Okay, but she wouldn't be able to get food stamps for herself, but her children included in her application, Miguel and Lupe, would be able to get food stamps. That's how it works. If she was a U visa and got a bona fide determination, she wouldn't be eligible for public benefits for any of these. You still have to wait in New York.
So let's tell you a little bit about VAWA confidentiality, because each one of these forms of relief is covered and they do have protection from VAWA confidentiality. Quick here, but have you worked with an immigrant survivor who A, received threats of deportation from the perpetrator, B, been contacted by immigration enforcement officials, or C, both? There's somebody that answered A, and I think most of us have heard about the threats of deportation from perpetrators because of the way the immigration system is structured with the sponsor and the beneficiary. It inherently lends itself to that power and control. And so we do often see the threats of deportation, especially if there's a pending criminal case or as a form of controlling the immigrant survivor. And so that's one of the reasons why Vawa Confidentiality is afforded to immigrant survivors. Tell us what the data that we're seeing, Leslie, is.
So basically, one of the things that we've learned from the social science research, and I'm going to, after I tell you about this, when Rocio's talking again, I'm going to put a new link in the chat where you can get even more up-to-date 2021 data. But basically, perpetrators are actively involved, like basically 39% or 38% of VAWA self-petitioning cases, the perpetrator is actively involved in trying to get her removed from the United States while her VAWA self-petition is pending. And we see that in 25% of U visa cases. Also disturbingly, and you can see a big rise in the U visas on this and a little bit of a rise in, is that particularly why do we start off with language access a little bit today? Is one of the things we're finding is that when victims call the police for help, or police show up on the scene of a domestic violence or a child abuse case or a sexual assault case, but particularly domestic violence cases, perpetrators are very good at triggering their victim's arrest, largely because of language access issues, because he's the one that speaks English on the crime scene. And we're seeing those numbers kind of rise over the last few years. So it's something to be aware of. And one of the reasons we'll be talking about in this section about why you want to screen these cases and get something filed as soon as possible so that DHS immigration officials, enforcement officials learn that this is a victim and they shouldn't go after her. Next slide, please.
And so the three major buckets of protections under VAWA Confidentiality is abuser provided information. So DHS, Department of Justice, or state they're barred from taking action against an immigrant victim based solely on the information provided by the abuser or the crime perpetrator or their family members or associates. The second one is the location prohibitions. And this prohibits enforcement unless DHS complies with specific statutory or policy safeguards, and that includes courthouse enforcement action against an immigrant crime victim. And lastly, it's the non-disclosure. So DHS, Department of Justice, State Department, USCIS cannot disclose VAWA confidentiality protected information to anyone through either civil, family, or criminal court discovery or anything contained in the protective case. And so that protects immigrant survivors in that manner. Here's an illustration to break it down. The non-disclosure protects victims who have filed for protection with a case with DHS. So that includes VAWA self-petitioners, battered spouse waiver, VAWA cancellation, UNT visas, and spouses of work visa holders like H-1Bs. And so they're protected by the non-disclosure part. The second one, abuser prohibited information, and that's taking information that the perpetrator says to USCIS. That protects all victims of abuse, whether they filed or have not filed. And it also protects victims that are in the process of applying for the U or T visa.
That's actually really important because in the process, the way DHS knows that is you all can play a role. As soon as you start working with somebody who might be applying for a VAWA or a T or a U, you want to give them a letter saying, this client is in the process of applying for a VAWA, T or U, especially if they're immigration related threats, so that you can, if she shows that letter to immigration enforcement officials, they must stop the enforcement action or suffer consequences in terms of their jobs. So it does work and it does help, and to understand that anytime you have the abuser is a spouse or a parent, there's a marriage or it's a parent-child relationship, they're always covered by this provision. They never have to file.
And then we said the location prohibition protects all victims, and it requires that no enforcement action happens in these protected locations. And we're going to tell you a little bit about that in another slide. Once a victim applies, they get put into a computer system. It's a red flag system, a 384 system, and it identifies which victims have already filed. So if they encounter an immigration official, they can look them up and know that they're protected by Vawa Confidentiality. It reminds immigration officers to afford these protections to victims of domestic violence, crime victims, or human trafficking victims, or any of the crime victims in that list that I shared with you for U visas. And so the memo says that whenever a DHS officer or employee receives the adverse information, so bad information that's going to impact their case or cause removal from a spouse or family member, they're going to inherently look at it as suspicious. The employee is directed to look into the central index system and check to see if they're protective, and then they'll be sensitive to the fact that the victim immigrant power control perpetrator dynamic may be at play. And to tell you a little bit about relying on the information provided by the perpetrator, the government cannot gather information from the perpetrator or the abuser, provided solely by, and that protects domestic violence survivors, child abusers, sexual assault or stalking perpetrators, the trafficker, any perpetrator of the U visa crimes listed, or their family members or a person associated with them. And they can't take adverse action like start immigration proceedings against them or detain them based on that information.
And this is basically a list of all the actions they cannot do if they get that information.
Yeah, so they can't deny the case based on that information, or detain, deport, initiate, or seek out or question or detain a victim based on that information. They cannot contact the abuser. So all these forms of immigration relief are confidential. The abuser will not find out that the victim has filed. It won't impact their immigration status in any way. Immigration cannot seek information from the abuser. So if there's something in the petition, they can't go and ask him, hey, is this true? And they can't call them as a witness, and information that they send in, because it has happened that they send in information, it cannot be used to make a determination in their case solely by that information.
And this is a policy, we've given this to you so you have the information if you need it, but basically it just reiterates that if the officer believes that somebody might be, even if they haven't filed, might be a victim who could benefit from VAWA or TRU, they're not supposed to enforce immigration against them based on information provided by the perpetrator. Next slide, please.
And so this is who VAWA Confidentiality covers: the VAWA self-petitioner, cancellation or suspension, battered spouse waiver, U visa, T visa, those that apply for continued presence, and abused spouses of work visa holders.
And that's the confidentiality provision. So that provision means that once those files are sealed, those are the cases where the files are sealed as opposed to the protections available. So those are the sealed cases. Next slide, please.
So some survivors are protected prior to the filing of the case if a victim shows evidence that they're in the process of filing. So the U and T visa, the VAWA case, that automatically starts to trigger the protections under VAWA confidentiality. And sometimes that evidence will look like a letter from the attorney or the advocate saying that they're starting to work on that process, maybe a copy of that U visa certification or a protection order. Carrying that piece of documentation can be crucial for an immigrant survivor, so it can trigger those VAWA confidentiality protections. And so a quick poll.
So have you had a perpetrator in a family court case that you've worked on try to A, raise the immigration status of the victim in the case, or B, obtain information about the victim's case through family court discovery? Has that happened to any of you? Or both? C. Seeing an A. We're seeing A's and C's. Yep. Some, okay, anybody else want to weigh in? So it's very interesting. This is something that has been on the rise over the last several years. And what we found is in courts, particularly in areas where, in courts where judges are signing you visa certifications or issuing special immigrant juvenile status orders that have reputations for being fair and safe places for immigrants to come, we see this a bit less, but the judges report this happening at all times, but victims are going to court. It's not scaring them away because the courts are acting appropriately. So that's a good counterbalance to it. But yes, this is something that does happen. And next slide, please. And so what's going on is the first one, they're trying to raise the immigration status as a way to intimidate victims. But what's important to understand is that the Vawa Confidentiality, when you file a Vawa, a T, a U, a continued presence, SIJS, no, Vawa T, U, continued presence, or a work visa holder case, those cases are all protected, which means that the perpetrator cannot go into court and use family court discovery to try to learn any information about that case. And the case law in this, and we have tons of case law in the materials that we're sending out to you. The case law on the case basically says, and that this protection lasts from the time the victim files until forever, unless the case is denied on its merits. So it could be denied because she got immigration relief another way, in which case it goes on forever. But if it got denied on its merits because they didn't qualify for a Vawa self-petition or something, then it would end. But on the discovery issue, cases in both family courts and criminal courts have ruled that they cannot get the case file or anything in the case file. And the only exception in criminal cases only is the criminal courts will allow discovery of the U visa certification itself, period. Only that one document. Next slide, please. So Rocio earlier was talking about sensitive locations. And this is just a list of all the different kinds of sensitive locations that are protected, which includes courthouses in context with protection order and custody in civil and criminal cases, but pretty much also covers many of the programs that you work at: shelters, rape crisis centers, visitation centers, family justice centers, and the like, are places where immigration enforcement against victims is prohibited. Next slide, please.
So if there's a violation of any of these protections that Leslie and I shared with you, there is some consequences, and that each violation can be a sanction against the federal government officials. They can be subject to disciplinary action. It could be a $5,000 fine for the individual that violated it. And immigration will dismiss the immigration removal case or deportation against the immigrant survivor.
Go ahead. No, you go.
Okay, so other sensitive locations include, there's no enforcement action by ICE or Customs and Border Patrol or to occur at schools, medical treatment, healthcare facilities, places of worship, religious or civil ceremonies, weddings, or during public demonstrations, march, or rallies.
Right, and this is really important, particularly the schools and the places of worship, healthcare centers, because these are places you should know that your clients can safely go. And for those of you that may be family attorneys on this call, these are places where safe exchange of children could be like a visitation exchange. They could be good ideas if you're not using a visitation center for safe places where if you're worried about immigration enforcement.
And so we know that it's best to screen victims as early as possible so they can get the protections from deportation and get VAWA confidentiality in place. We want to encourage you to share with them a letter so that they can carry, so that they could let them immigration officials know, or anyone they encounter, that they're in the process of filing the case, because we learned about some protections that happen even before filing. And in some cases, safety is improved if the immigration case is filed first. So if you're filing for a protection order and you know that perpetrator is going to want to call immigration enforcement, well, by having that immigration application in, it offers that safeguard prior to that, because we have to serve the protection order to the perpetrator. We don't want him to trigger or her, the abuser, the immigration case against the survivor. And so think about that when it comes to protection orders or divorce or custody cases. If a survivor is traveling to a new location, especially when you already know that you've screened that the survivor is getting immigration threats from the perpetrator. And sometimes they can file an application with sufficient evidence just to get it started, and then you can supplement it at a later date.
And it's really important. I just did a training a few weeks ago for all the adjudicators at the Vermont Service Center on VAWAs and U visas. And one of the things that we mentioned that we trained them on was the fact that we're encouraging the field, because of these VAWA confidentiality issues, to file applications that contain prima facie or enough evidence to get prima facie or bona fide determination that will be supplemented later with an RFE. And what the adjudicators told us to tell you is the way they're set up, it would be better for them. And so let's say you do this, then you don't have to wait for an RFE, the request for further evidence, to supplement your case. So you can get something initially in, and then you can augment the evidence as soon as it's available. And if you do that, you will get a swifter adjudication ultimately in your case. So that really is the best practice. Get something in, get your VAWA confidentiality, make sure it has enough for bona fide or prima facie, so you don't get kicked to a longer list essentially of adjudication process, and then go ahead and supplement it as soon as you can. It's also closer in time for you and the victim as well. So it'll make the case go faster. So now, yes?
Just a quick question. Can ICE or CBP go to those locations under the auspice that it could jeopardize VAWA self-petitioners? I'm not sure if I understand what that.
So I think so here's the issue. If something is can you go back to the last protected location, the sensitive location list? That list, okay. If something is on this list, it applies to all immigrants, not just victims. So this is protected for all immigration enforcement. The courthouse protection, well, actually it's just changed. So the courthouse protections are VAWA. That other list that we showed you is VAWA specific for it's victim specific, not VAWA petitioner specific. So it's victims who have protections at those locations, not just any immigrant. So that's how that works. Okay, so now we're going to take a dive for the next half hour or so into the details of what is available, what's publicly funded and available for immigrant survivors. And we're going to start with what somebody can get without regard to their immigration status, because you're going to encounter victims who you haven't filed for yet. And so I want to start, or who may not qualify for something, or who may be too afraid to file or something like that. This is what everybody gets without regard to their immigration status. They get access to legal services. They can go to family courts. They get language access, police protections, protection orders. They can have their abuser criminally prosecuted. They can apply for benefits that their children qualify for. All crime victim assistance programs. So VOCA, for example. Shelters, transitional housing. There are no immigrant restrictions on transitional housing programs. They can participate in WIC, school lunch programs for primary and secondary education, emergency Medicaid, immunizations, COVID treatment, and care from community and migrant clinics. Next slide, please. In addition, they can get services, all kinds of services that are in-kind services provided at the community level, not based on an individual incomes and resources that are deemed necessary to protect life and safety. Next slide. And I'll go into the details of the life and safety in a moment. Before I get there, though, this I actually kind of did this. This just reiterates what kids can get in terms of school lunches, education, immunizations, et cetera. And the kinds, next slide, the kinds of temporary service, the kinds of services that are available as necessary to protect life and safety is quite broad. Adult and child protective services, crisis counseling and intervention. This is without regard to where the money comes for these programs. Violence and abuse prevention, victim assistance, treatment for mental illness or substance abuse that is necessary to protect life and safety. Help during, hurricanes, soup kitchens, community food banks, as I said, shelter and transitional housing, nutritional programs for those requiring nutritional assistance. Next slide, please. And that legal services, even Legal Services Corporation, all legal services agencies, including those funded by the Legal Services Corporation, can provide assistance without immigrant restrictions through anti-abuse laws to all of these different kinds of victims that we're talking about today. So victims should not be being turned away from any legal services. Next slide, please. When children qualify for, there will be times where many of your clients, let's just do a little raise your hand. Let's see if I can see the participants. Raise your hand if you've worked with victims who are undocumented but have US citizen children. See how many of you are awake. There's more than two.
We got about 4 raised hands. Yeah.
Yeah, we got some raised hands. That's right. Many of you do work with parents who have children who are citizens. Undocumented parents, parents applying for immigration relief can all file applications on their children's behalf to receive benefits that their children are eligible to qualify for. And the benefits, believe it or not, the way the law is written, even today, and it's been like this for decades. And this is one of the reasons we're going to be talking, we're giving you this public benefits information because we want you to be sure that you should not be sending immigrant parents and children, immigrant parents, to apply for, or immigrant victims to apply for public benefits by themselves unaccompanied. There are language access issues, but there are also victims will often get turned away who qualify. And as I'm going to explain right now, if you have a parent applying and a child, not for themselves, but for their children, the federal law says that if I'm a state benefits worker, this is what I'm supposed to tell you if I'm going to ask you questions about the undocumented parent's status or social security number. I'm supposed to basically say, I'm going to ask you a question that right now that you don't have to answer. And if you answer this question, I must turn that information over to the Department of Homeland Security. So you have a right now to answer the following question, which is, can you tell me what your immigration status and social security number is, or social security number is? That never happens. There people just ask because they don't know it, or they think the children and they ask about the parents, so they don't do it right. And the reason we need people to accompany is so that they do it right. So they're not supposed to ask any questions about immigration status or the social security number when a parent is of anybody who's not applying for the benefit themselves. So they can ask the question about a Vawa self-petitioner who's applying on their own. They can ask it about the child who's going to get the benefit, but not about other family members who are not asking for additional funding, I guess you could say, on their own. Next slide, please. So as promised, we have this cool tool we developed. We have a great bunch of undergrad interns who put this together. And this is our interactive benefits map. Next slide. And basically what you can do on the benefits map is you can look at all of these public benefits programs. Unemployment is not finished yet, but everything else is. And you click on the program and you'll get a map like you saw on the last page. And then you click on New York and you will get the detailed information about what what VAWA self-petitioners, U visas, T visas, DACA, SIJS, undocumented clients qualify for under each of these programs by state. Is there another slide coming? Yeah. And so next slide, please. So that when you get there, when you go to the map, it will say eligible, eligible with conditions, not eligible by immigration status. So if you have a victim where it says eligible or eligible with conditions, you can then at the bottom of the page, click on a map, a link that takes you to a detailed public benefits map where you can see exactly all the rules about how your victim applies for TANF, qualifies for TANF, or for food stamps, or for WIC, or whatever, with all the footnotes so you can go and print out the materials to take them to your public benefits agencies. In addition, we have state-by-state charts around healthcare access through VOCA, emergency Medicaid, forensic exams, and prenatal care. Next slide, please. And so these are super important, as I was talking about, to accompany victims who are applying for public benefits, because part of it is you're there to educate the benefits workers, because you have a client. I mean, New York is probably going to be better in some parts of the state than others, and better than some other states in terms of what the benefits workers may already know, depending on the number of immigrants that might be eligible for services and benefits in that community. And you'll have some communities with larger number of immigrants than others. And I'm sure in the more rural areas of the state, your benefits workers are going to be less familiar. But that's why Rocio and I and our program offers technical assistance on this. So you can go look at the New York chart, find the resources. So let's say you're going to go apply for food stamps for your VAWA self-petitioner children, self-petitioner clients' children who are included in the self-petition. Maybe there's 2 included in the self-petition and 1 citizen child. You're going to go get food stamps for the 3 of them. You can go to the footnotes in the chart and print out both the federal law rules regarding that, but also you can print out under New York state law how your self-petitioner client also qualifies for TANF and where the law that says that is, so that you can show them their own laws, their own websites using our footnotes. If you're using your chart and you're having trouble accessing something, call us. That's part of the TA. That's how we update the charts, is that you let us know something's wrong or something's off. I think there have been a few updates to the New York chart in the last year or so that I kind of discovered, and when I was making the slides last night, so we're going to take a look at that. But it's a tool that'll be very helpful to you, and you want to accompany them so that you can make sure their kids get what they're entitled to. But generally, victims who are eligible also need advocacy with the state welfare workers to make sure that they're not asking questions they shouldn't, and that they're not saying no to your client because their last name is Garcia. You know, they're not discriminating. But it's super important, and it's a really important role that all of you can play. Next slide, please.
Right. And there's a lot of misinformation in the media or what happened during the last 4 years about what they can access or what consequences it has. And so often immigrant survivors say, well, can I apply for this? Is it going to affect me? But for immigrant survivors of these crimes, it's really important that they access everything that is available for them, because that's what's going to keep them safe. And that's what's going to support them through the process of becoming self-sufficient. And so just really quick poll, and let's just get through this quick, but what would you take with you to the benefits agency with an immigrant survivor? And so A, what Leslie said, bring a copy of the state and federal benefits statute that she showed you that would be there in the public benefits map, DHS documents showing that the victim is eligible, so the receipt notice, any relevant or state federal policy, or D, all of the above. And so everybody's paying attention, everybody said D. Let's go on to healthcare.
Right. So where can immigrant survivors receive healthcare that is subsidized, free healthcare without regard to immigration status? Anybody know? Where would you send your client?
And you're
undocumented client, they need free healthcare. Where can they go that the government will pay for?
And earlier you shared that everyone's eligible for emergency healthcare. So we're talking about more than that.
Well, right. So the emergency room, actually, it's interesting. I'm glad somebody put the marketplace. Actually, the marketplace in New York, there are ways different immigrants can go to the marketplace, but under federal law, they're not all immigrants are entitled to the marketplace. So you'd have to go under, particular New York programs. So for example, a DACA child in New York can get full Medicare under New York, Medicaid under New York law, but can't purchase through the exchange. So it's very tricky. But where everybody can go is emergency rooms. And yes, we got the answer, community and migrant health centers. That is exactly right. HHS funded, next slide, please, community and migrant health centers. So you can click on these links and it will take you to a web page where you can find the community and migrant health center closest to your clients. There are state-funded programs, post-assault healthcare, any healthcare related to VOCA funding is no immigration restrictions, and emergency Medicaid, which covers COVID treatment and care, no immigration restrictions. Next slide. The next slide actually shows you what the HRSA website looks like about how to look up the addresses of where they are. The next slide gives you a list that you can use after the training of all the different kinds of healthcare provided by the migrant and community health centers. The next slide talks about emergency Medicaid. So what does emergency Medicaid cover? And they cover basically anything that would, where the patient's health is in serious jeopardy or that would result in serious impairment to bodily functions or a dysfunction of a bodily organ. So I already tipped the hat on COVID treatment and training, testing. What else would get, what's the biggest thing that like immigrant victims, other than physical injuries, when do your clients need emergency health care, emergency Medicaid?
So
Pregnancy, not pregnancy actually. Although in New York, you're right, pregnancy, prenatal care and healthcare during pregnancy is covered for free to everybody in New York. And, childbirth is part of emergency Medicare. You are right, Cheryl Lynn, about PruCall, and we'll get to that. And so that PruCall is people who are present under color of law, which means they filed an immigration case. Those people generally are eligible for certain kinds of healthcare in New York, and we could talk about that. Psychiatrists working at community health clinics would be covered. Obviously, sexual assault treatment and care also. Next slide, please. Okay, so healthcare, they're eligible under the migrant and community health centers, regardless of immigration status. Families First Act, additional funding to pay for coronavirus testing covers, and emergency Medicaid also, as I said, covers coronavirus treatment. Next slide. We have further information about CARES Act coverage for healthcare at this link. And we also talk about basically victims who have work authorization work authorized social security numbers, and there may be VAWA and U visa victims who have work authorization and social security numbers who are undocumented. They don't actually have a visa yet, but that's fine. They qualify for CARES Act payments and provided they file tax returns. And those people who are eligible for work, if they're work authorized and have an SSN, then they also qualify for unemployment insurance. Next slide, please. And this gives you an overview of the federal law regarding unemployment insurance. We're starting to do the state-by-state tracking of this law. We'll be doing it this semester and next. So immigrants are eligible for unemployment insurance if they're authorized to work at each of the following times: when they did the work, at the time they filed for unemployment benefits, and during the entire time they're receiving unemployment benefits. They must be able and available to work. and must be call during the base period. So this is, they must have a pending immigration application that gives them gives them authorization to work. And we have a publication that tracks all the different statuses, every immigration status you could imagine where they'd have SSNs and work authorization. So you have a nifty checklist through our CARES Act publication on for employment eligibility. Next slide, please. So undocumented, as I mentioned, undocumented victims have access to shelter, emergency shelter, and transitional housing. And that includes homeless shelters, domestic violence shelters, trafficking victim shelters, and transitional housing. Next slide, please. If you've worked with an immigrant victim who was turned away from a transitional housing program, can you check, let us know, like A, B, C, or D? Were they told they couldn't qualify because they didn't have work authorization? Were they told they didn't qualify because of the victim's immigration status? Or were they told they didn't qualify because of lack of self-sufficiency, or all of the above? We see one person so far has answered that it was D, all of the above. We see some B's, lack of immigration status. Yeah, these are common things we're seeing nationally. And good news is they're illegal. None of these should be requirements that should be legally applied by a transitional housing program. None of the money that funds transitional housing programs has restrictions by HUD, by VAWA, by VOCA, by any of the funders, and the programs are imposing these restrictions, which is discriminatory. So we have some nifty tools. I'm going to go over the law, but we have, I'm not sure, Rosie, maybe you could find the tool, we could post it. We have a tool, it's called, I think it's the law, Rocio. Yeah, and we have a tool on how to advocate for victims, because many of us are working with immigrant victims who actually are working, right? They don't have work authorization, but they actually are working. And if they are working, then they can show employment, and they can show the fact that they filed an immigration case and have it pending are steps towards self-sufficiency. So it's a brochure that walks you through how to show victims actually meet these requirements that they shouldn't be having on these programs. So you could either fight them argue with them about the programs, or if you have a victim who actually can meet the qualifications in a different way, I find it's better to advocate and help that client meet it, and then talk to them about why they shouldn't have these requirements. Next slide, please. Housing providers under federal law who receive DOJ, HUD, or HHS funding have been ordered since August 2016 not to turn immigrant survivors away from emergency shelter, transitional housing, or rapid rehousing programs. Next slide, please. And that applies to programs funded by the Violence Against Women Act, the Family Violence Prevention and Services Act, Crime Victim Act, and HUD-funded emergency solutions and continuum of care programs. The next slide has a summary of the HUD Office of Special Needs, basically, and what their statement about all of the programs that don't have immigrant restrictions that they fund. So you can look these up here. Next slide, please. And these are the anti-discrimination provisions that you can use that they're violating when they're turning immigrant victims based on immigration status or language or whatever they're making up away from transitional housing programs and emergency shelters. Next slide, please. And that the access so that all of that time I've been talking is pretty much a lot about what everybody gets. And now I'm going to show you how, as Clara and her kids go to apply for immigration relief, their access to public benefits in New York grows. Next day, actually nationally and in New York. So there's different. This is again a checklist for you to use after the training. But there are two different categories. There are two different benefits categories. There's qualified immigrants. And that's all, anybody who you're working with is a lawful permanent resident, including people who got their lawful permanent residency through the U visa or SIJS programs, or any path actually. Refugees, asylees, VAWA self-petitioners, and trafficking victims with either T visas or continued presence are qualified immigrants. Asylum applicants, DACA recipients, U visa applicants and recipients, student and work visa holders, and the undocumented are generally less eligible, not eligible in most states for anything. In New York, some of them will be eligible for some things, and that's what I'll be walking you through. But generally speaking, those are the two buckets. Whether a victim qualifies for federal public benefits and state public benefits depends on their immigration status, when they entered the United States. People who entered before August 22nd, 1996 have more access to benefits than people who entered after that date. So you might be working with youth, in their 20s who entered before 96. And so you want to check that with younger victims and older victims. And so don't just think because, most of the victims you work with don't qualify. You really do want to look at when people first enter the country, because that may give them a lot more access to benefits than before. So, and also each program has different benefits, qualifications, and every state is different. So what they're going to get in New York is different than New Jersey, is different than Connecticut, is different than Pennsylvania. So who are qualified immigrants? Oh, no. So some examples of federal benefits program, next slide, please, is, so basically, okay. So the only things that are considered federal benefits as a matter of law are programs that give money to an individual, a household, or an eligibility unit. So if TANF money in New York goes to a women's shelter, the money is going to the shelter, not the victim. It is not restricted. That's the way to think about it. Next slide, please. So examples of federal public benefits include contracts, grants, loans, things like driver's licenses, retirement benefits, healthcare, disability, post-secondary education, housing, food assistance. Next slide, please. So the people who are qualified immigrants include this list. So here's a checklist you can look at to see who of the people you're working with are qualified immigrants. You'll notice on this list, you have T visas and VAWA self-petitioners, among other people. Next slide, please. And that people who are qualified immigrants get a whole range of access to federal public benefits. This is federal law gives them this. Public and assisted housing, post-secondary educational grants and loans, the additional help beyond the immediate disaster for FEMA, adoption assistance, disability benefits, things like that. Next slide, please. So, and I think this is our last poll, I'm not sure. Which of the following are not eligible for public and assisted housing? A, B, C, or D?
So A, lawful permanent residents, refugees, and asylum recipients. B, VAWA self-petition applicants. C, U visa applicants and recipients. Or D, bona fide T visa.
I'm seeing B, I'm seeing C. B and C. Give them a few more time to respond. So lots of B's, a couple of C's. The true answer is C. VAWA self-petitioning applicants, the moment they apply, are eligible for public and assisted housing with no proration. We'll walk you through that as we go through in a second. Lawful permanent residents, asylees, and bona fide Ts all are eligible for public and assisting housing. U visas are not. Next slide, please. So VAWA that's in the wrong, going backwards.
Sorry.
Next slide, please. There we go. So VAWA self-petitioners are eligible for HUD-funded public housing with no proration the moment they file their VAWA self-petition. And these two slides walk you through, and we have tools that we'll send you about how to advocate for that, because next slide, please. The next slide shows you how to tell the public housing authority to work the SAVE system to get verification of VAWA self-petitioner eligibility. And VAWA self-petitioner eligibility includes both people who filed VAWA self-petition, VAWA cancellation, VAWA suspension, because I'm talking to people in New York, VAWA Haitians, VAWA Cubans, all those VAWAs. And it also includes somebody who's abused, whose batterer filed a family-based visa petition that's been approved, where they've been abused. So it's a very broad group of people who are abused by US citizen or lawful permanent resident spouses or parents. Next slide, please. And I just want to say, as to the question about abusers reporting victims who got stimulus money, that is exactly the kind of question that you can call us for technical assistance, and we can work with you on to figure out, whether they were eligible and all, because the batterer may have thought they weren't eligible, but they totally were. And that's very likely to have happened depending on the case. And that's the kind of thing you can call us for technical assistance. Okay. So now we're going to take the last few minutes. We're going to go over big picture overview of who gets what in New York, the pièce de résistance of this training. Next slide, please. So TANF, under New York state law and federal law, the people who get TANF are bona fide T visa applicants, people who receive continued presence, VAWA self-petitioners with prima facie. And by the way, from all the slides forward on this, when I write VAWA, I mean VAWAs with prima facie, except for the only thing VAWAs get before 3 months when they get their prima facie determination, the only thing that doesn't require that wait is housing, public and assisted housing. Refugees, asylees, pre-1996 entrants, or 5 years after lawful permanent residency for U visa and SIJS. Childcare. So this is interesting. There's several forms of childcare. Child Care Development Fund training and Child Care Development Fund, Child Care, and New York City's early learning programs have no restrictions. Other than that, if it's a TANF funded program, it's T visas, people with continued presence, VAWA self-petitioners with prima facie, and asylees, refugees, and once U visa applicants and SIJ applicants receive lawful permanent residency, they're eligible with no waiting period. Food stamps, refugees, asylees, continued presence in T visas, bona fides, get food stamps. For VAWA prima facie, basically VAWA prima facie is it's only if they're children, elderly, or disabled. After lawful permanent residency, whether you're a VAWA or U or SIJ, if children, eligible, disabled, or 40 quarters of work credit. So adult VAWA self-petitioners only get it 5 years, only get it, not 5 years, only get it if they're elderly, disabled, or have 40 quarters of work credit. And the details of that, if you have a case, call us and we can walk you through. We have tools and training materials. Next slide, please. Healthcare exchanges. The people who can buy on the exchange are VAWA with prima facie, continued presence, asylees, refugees, T visas, U visas with deferred action, and SIJS applicants. So here, if U visas got deferred action, either through the new bona fide program, which is supposed to come quicker nowadays, soon, or because they're on the wait list, they qualified to purchase healthcare on the exchange. Under the essential plan for New York Health Insurance is available at low cost. And for VAWA and U visa applicants with deferred action, New York Basic Health Program for people under 135% of poverty. There's a whole list there, and that's where DACA kids get subsidized healthcare. There's no restriction if you're pregnant or if you're a child, you can get healthcare in New York without restrictions through either the Child Plus program or one of the other programs listed above. Full scope Medicaid is refugees, asylees, is federal Medicaid, continued presence, T visas, and under the state law, DACA. CARES Act, I talked about. There is LAHEAP, which is health assistance with emergency heating and cooling, is available to VAWAs, Ts, and asylees and refugees, but not use an SIJ until lawful permanent residency. And only one person in the family has to qualify. We've got one more New York slide and 2 more slides and we'll be at the end. Public benefits in New York also. Okay, education. Federal post-secondary educational grants and loans through FAFSA is VAWA self-petitioners, trafficking victims with T visa, bona fides, or continued presence, and that U visas and SIJ don't qualify until they get lawful permanent residency, but when they have lawful permanent residency, there's no wait. There's a typo in the slide, sorry about that. No immigrant restrictions for New York residents to CUNY and SUNY. New York State DREAM Act held students who graduated from New York high schools with financial aid. SSI is the worst. Very few victims get SSI. It's basically, you know, with few exceptions, unless you're working with a VAWA victim who entered the country, you know, pre-96, it's going to be trafficking victims. And this is where, like, going back to Clara, if she needed SSI, you want to file a trafficking victim application for her or she won't get it. Driver's licenses, you only get federal recognized driver's licenses in New York, and those come when the VAWA self-petition is approved or the victim gets a bona fide determination and gets work authorization, T visa bona fide, U visa wait list or bona fide, DACA, continued presence, and SIJS, they have to wait till lawful permanent residency. And the last point I'm going to make, as I'm trying to stay within a couple of minutes of being on time, is that immigrant victims are exempt from public charge. There's a lot of, next slide, please. Immigrant victims are exempt from public charge. There's a lot of misinformation, but basically VAWA Ts use SIJ, refugees, asylees, DACA holders, U visa, many visa holders, most lawful permanent residents are exempt from public charge, but certainly almost all victims we've been talking about today. So now the last point is I want to invite you to call us for technical assistance. Our information is on the next slide, Lucio. And this is our phone number. You can call us. You can go to our, it's 202-274-4457. And you can email us at info@newop.org. And we're happy to answer your questions. I wanted to thank you for joining us today and for your participation and for asking questions and for opportunities from Otsego to sponsoring this event. Next slide, please. And we'll leave you with a picture of our front page of our web library where you can see the various different topics that are available. Thank you so much for joining us today, and we hope this was helpful.
Thank you, everyone, for the work that you're doing, like Leslie said, and feel free to reach out to us for technical assistance. We're here to support you in your work, and if this triggered any questions or, you know, hopefully we were able to share with you the information that we promised, and as this triggers more information, we're here to support you. I'm going to email you a link to these slides so that you can print them out and have them there available, and other complimentary resources to support you in your work. Have a great day and see you next time, everyone. Bye.
Thank you so much.